Hey, welcome back. Come on in, pull up a chair, because I am genuinely glad you're here for this one. Not glad in the polite YouTube outro way. Glad the way you're glad when you get to tell someone a story you've been sitting on all day. So let's skip the part where I tell you what this video is about, and just start where the story starts, which is with a man who has spent 41 and a half years on the federal bench learning exactly one lesson, that when the United States government tells a judge, "Trust us," the correct response is, "Show me." His name is Emmet Sullivan, and on Thursday, in a Washington courtroom, with the phone line jammed to capacity because so many people wanted to listen in, he looked at 3 Department of Justice lawyers and told them, essentially, that he has done this before. He has held federal prosecutors in contempt of court before. He did not enjoy it then. He does not want to do it now. And then he said the sentence that is the entire reason we are here today. That isn't a threat. That's a promise. Sit with that phrasing for a second, because there's a version of this story where a judge yells, bangs a gavel, and everyone moves on. That is not what happened. His voice, by every account from people who were in that room, never rose. It's the frustration underneath it that rose. And that, of course, is somehow so much worse. Now, before I go any further, let me tell you what this is actually about, because Epstein Files hearing is one of those phrases that has been said so many times in the last year that it has started to lose meaning, the way any word does when you repeat it too many times in a row. So, let's rebuild the meaning. Congress passed a law, a bipartisan law signed by the president himself, called the Epstein Files Transparency Act. It required the Department of Justice to release the full investigative record into Jeffrey Epstein and Ghislaine Maxwell by December 19th of last year. That deadline came. That deadline went. And an independent journalist named Katie Fong did the thing that, increasingly in this country, only individual citizens seem willing to do anymore, which is sue the federal government to make it follow its own law. She filed in April. By late June, Judge Sullivan had already ruled that the Justice Department had effectively admitted it was in violation of the statute, not that Fong had proven it, that the government itself had conceded it, and he issued a preliminary injunction ordering compliance by July 2nd. July 2nd came. July 2nd went too. Which brings us to Thursday and to a Justice Department attorney named Andrew Block, who was sent into that courtroom to answer for all of it, and who, according to everyone who watched him do it, could not. Here's what makes this genuinely fascinating to me, and I mean that as a compliment to absolutely nobody involved. There wasn't one document at issue. There were, structurally, 4 completely separate categories of failure, stacked on top of each other like a very poorly built Jenga tower that the government keeps insisting is architecturally sound. Category 1, the redactions. When the DOJ released its tranche of Epstein documents, huge sections were blacked out, and the government's justification was that these redactions protected victims. Fine. Reasonable even, on its face. Except, the law doesn't just let you redact and walk away. It requires you to publish in the Federal Register, a public government record. The place laws and rules are supposed to be visible to the people they govern. A specific written justification for every redaction. Not eventually, not we'll get to it. The statute uses the word accompanied, which, and I promise I am not the one being pedantic here, Judge Sullivan is, means at the same time. They have not done this, not once, not for a single one of what appear to be thousands of redactions. Category 2, and I want you to actually picture this one rather than just hear it, because I think it's the most important thing in the entire case. Somewhere in a government file cabinet, there are reportedly 30 or 40 pages of handwritten FBI notes taken during interviews with a woman who, as a 13-year-old, alleged that Donald Trump sexually and physically assaulted her. The government did not turn those notes over. What they turned over instead was a typed summary, an FBI 302 report, for anyone who wants the paperwork term. And when the judge asked why the underlying handwritten notes weren't produced, the government's lawyer said they were duplicative, substantially the same information, just in typed form, so no real loss. Which is a claim that only survives contact with reality for about as long as it takes someone to ask an obvious follow-up question, which Judge Sullivan did repeatedly. How many pages specifically are we talking about? What, specifically, is difficult about redacting them? And the answer, 4 separate times, was some version of, "I don't know, Your Honor." Now, of course, a Justice Department attorney showing up to a hearing he knew was coming, about an order he knew existed, and simply not knowing the answers. That's not incompetence. Incompetence would almost be a relief at this point. This was a man sent in specifically because he didn't know the answers, so that nobody in that room could be blamed for lying. Category 3 is the Federal Register publication itself, which we've already covered, and Category 4, and this is almost a footnote compared to the other 3, except nothing involving 13-year-old victims and a sitting president should ever really be a footnote, is that there are apparently foreign language documents in the file that, by law, need English translations. And the government's excuse there was, and I want to get this exactly right because you genuinely cannot make it up, that translating them wasn't all that practical. Practicality. That's the standard now, not legality. Practicality as determined, presumably, by the same people who decided it also wasn't practical to hit a July deadline, or a December deadline, or to bring a lawyer into a federal courtroom who had actually done his homework. So at some point in this hearing, after roughly an hour of getting nothing but "I don't know" from the government's side, Judge Sullivan took a short recess. And when he came back, force of habit. There's no Brian here, it's just you and me. When he came back, he didn't ask another question. He told a story. And this is where I think the entire hearing tips from frustrating legal update into something you actually need to understand if you want to understand where the United States is right now. He told the room about a case he presided over back in 2008, the corruption trial of Ted Stevens, then the longest-serving Republican senator in American history. Federal prosecutors, in that case, withheld more than 30 pieces of exculpatory evidence, evidence that could have helped Stevens defend himself, which is not a technicality, it's a violation of the actual United States Constitution. Stevens was convicted, he lost his re-election, and months later, once an FBI whistleblower exposed what the prosecutors had hidden, the conviction was thrown out entirely, and Judge Sullivan held those prosecutors in contempt of court. Stevens tragically died in a plane crash before he ever got to see his name fully cleared, and Sullivan, sitting in that same seat almost 2 decades later, was clearly not telling that story for the acoustics. He was telling 3 government lawyers, quite plainly, that he has watched this exact pattern before. He has punished it before, and he is entirely willing to do it again, this time over documents connected to the sitting president himself. Now, here's the part where I think we actually have to talk about why. Because a hearing like this doesn't happen in a vacuum, and I don't think it's especially controversial to point out the incentive structure at play. The man who currently runs the Justice Department's legal defense of Donald Trump, Todd Blanche, spent years as Donald Trump's personal criminal defense attorney before he ever held a government title. His predecessor, Pam Bondi, was fired earlier this year and has since told lawmakers, somewhat remarkably, that the redaction failures were simply errors. Errors as a category tend to be things you fix once someone points them out. These were not fixed. They were defended, stalled, and then defended again by a junior attorney sent in specifically equipped with nothing. So, when you ask, why would the Department of Justice risk contempt of court rather than hand over paperwork? I don't think you need a conspiracy theory. You need to ask a much simpler question. What, specifically, is in 30 or 40 pages of handwritten notes describing 4 separate interviews with a girl who says the president assaulted her? That is worth absorbing this much institutional risk to keep hidden? Because whatever that answer is, it is very clearly, in the eyes of the people currently running the Justice Department, worth more than compliance with a federal judge, worth more than compliance with an act of Congress that the president himself signed, and this is the detail that I think should genuinely unsettle you, worth more than the credibility of the Department of Justice as an institution that Americans of any political persuasion are supposed to be able to trust with evidence. Because that's really the consequence here, isn't it? Not the redactions themselves, not even as gutting as it is, the specific documents about a specific victim. The consequence is what happens to a country when its own Justice Department starts operating on the assumption that federal court orders are more of a suggestion than an obligation, negotiable, delayable, survivable through enough hemming and hawing. There's a legal doctrine called the presumption of regularity. It basically means that, historically, when the government tells a court, "Trust us, we did this properly," the court extends the benefit of the doubt. It's baked into the system because functioning democracies genuinely cannot operate with every single government action subjected to full forensic audit. Some basic trust has to exist, or nothing gets done. And what's happening in Judge Sullivan's courtroom, and in more than a few other federal courtrooms lately, including one down the hall where a different judge dealt with the government's handling of deportation flights to El Salvador, is that presumption quietly dying. Judges are no longer taking the government's word for it. They are demanding paper. They are demanding the underlying documents, not the summary of the documents. And when you actually stop and think about what it means for federal judges across multiple unrelated cases to have independently arrived at the same conclusion, that this administration's Justice Department cannot be trusted to accurately characterize its own conduct, that is not a partisan observation. That's just, at this point, a documented pattern. So, what actually happens next? Because I did promise you consequences, and a judge is annoyed isn't really one. Judge Sullivan didn't hold anyone in contempt on Thursday. What he did was something a little more surgical, and honestly a little more chilling if you think about it for more than 5 seconds. He told the government, plainly, that a black mark like a contempt finding follows a lawyer for the rest of their career. He's not threatening the institution. He's threatening the individuals sitting at that table, by name, on the record, in a room with a packed public phone line. He invited Fong's legal team to draft a proposed order, specifically addressing the handwritten notes and the Federal Register failures. He said he'd personally conduct a sealed review of those notes himself, rather than simply take the government's characterization of them on faith, which tells you, all on its own, exactly how much faith is left in the tank. And civil contempt, if it comes, doesn't work the way people assume from movies. Nobody gets thrown in jail on day one. It's daily fines, personal ones, imposed specifically to make compliance cheaper than defiance, right up until the moment it stops working, at which point you're in an entirely different, much more serious conversation about criminal contempt, hearings, and the possibility of actual jail time. Sullivan has walked exactly that road once before, with the Stevens case. He got compliance the very next day. He is, by every indication coming out of that courtroom, entirely prepared to walk it again. And look, I want to be honest with you about where I land on all of this, because pretending to be neutral about whether the government should hand over evidence in a case involving an alleged child victim would be a strange kind of cowardice. But I also want to be honest about the limits of what we actually know, because that's the other thing that's gotten lost in a story this emotionally loaded. We do not know what's in those handwritten notes. Nobody watching this video does. Not me, not the plaintiffs, and going by Thursday's performance, arguably not even the government's own lawyer standing in that courtroom. It's entirely possible the notes really are close to duplicative of what's already been disclosed, and the government is simply too institutionally allergic to transparency at this point to say so credibly. It's also possible they are not remotely duplicative, and that's exactly the point. The only way anyone finds out is if a federal judge with 4 decades of scar tissue and a documented allergy to being lied to actually forces the issue, which is, when you strip away every ounce of political theater from this story, the entire function the judiciary is supposed to serve in the first place, not picking a side, just making sure the paperwork matches the promise. There's something almost darkly funny about the fact that the government's own defense, deployed over and over across 4 separate categories of documents, kept boiling down to some version of, "We're working on it and we can't tell you when." Because if you've ever had a landlord say that about a broken heater in January, or a contractor say that about a bathroom that was supposed to take 3 weeks and is now entering month 4, you already understand, on a gut level, exactly what that phrase means. It doesn't mean the work is coming. It means the person saying it has calculated that stalling costs them less than finishing does. The only difference here is that the landlord eventually usually just gets sued in small claims court. The Department of Justice gets a 79-year-old federal judge telling war stories about a senator who died in a plane crash before his name was cleared, and calmly explaining, without ever raising his voice, exactly how the machinery of contempt works, one gear at a time, as a professional courtesy, so that nobody in that room can later claim they didn't see it coming. I'll leave you with this. At one point in the hearing, arguing for why the court should keep the case sealed rather than public, someone made the point that all of this scrutiny was, in some sense, unfair pressure. And Judge Sullivan's answer to that, more or less, was that the public has a right to know what the hell is going on. Not the public might benefit from knowing. A right. Coming from a man who has been on the federal bench longer than most of the people reading redacted documents on their phones right now have been alive, that's not rhetoric. That's a description of the job. Whether the Justice Department actually complies, or whether we're back here in another month watching the exact same lawyers say, "I don't know," to the exact same questions, is genuinely an open question, and I'm not going to pretend I know how it ends, because as I record this, nobody does, not even, I suspect, the people currently deciding what goes in that next binder. What I can tell you is that the last time a Justice Department lawyer tried this exact strategy in front of this exact judge, it took him exactly one contempt finding and one overnight recess to suddenly discover where all the documents had been hiding the entire time. Funny how that tends to work out. I'm Marcus Fenn. This is Borderlines. If you want to actually understand what's happening to the rule of law in this country instead of just doom-scrolling headlines about it, subscribe, because we're just getting started. And something tells me this particular binder is going to need a sequel.